Welcome to the 2025 Welcome to the 2025 State Privacy Legislation and Regulation Roundup. I'm Mike Signorelli, the co-chair of Venable's Technology and Innovation Group, and I'm joined by my colleague, Ali Monticollo. Ali and I regularly provide this briefing, typically at the mid-year point like we're doing now, and also again at year-end to provide a recap and a forecast in the coming year. And during these sessions, we share our insights from the policy work we do across all 50 states and before Congress, as well as counseling and investigative work that we do to support our clients. A little bit of a housekeeping before we walk through the agenda. We welcome your questions. Please submit them through the Q&A button, and we'll try our best to address those throughout the webinar. And also, this is a CLE, so we will be offering credit, and we will provide you a CLE code throughout the webinar. So make sure you take note of that and file your paperwork so you get your 1 hour credit for this session. So why don't we jump to the next slide? And for our agenda, we're going to start with a baseline of the existing state privacy laws, not a deep dive in any way, but mainly just so we have that baseline for comparing what's coming into the into effectiveness in the way of new state laws and amendments. Then we'll look at 2025, the real focus of our conversation of what has changed this year. What's interesting is that there has been no new omnibus privacy laws passed in the states, but there have been a number of amendments to existing privacy laws. It's certainly a trend we've seen the last couple of years that once a law is passed, legislatures come back to keep pace or outpace their counterparts. So we'll walk through some of the nuances there. And then finally, we're going to look at some of the new enforcement actions from this year and take out some of the key counseling points, the practitioner points for you. So Ali, please take it away.
Sure. So as Mike said, we're going to start with a baseline of what's happened in the U.S. This chart or this map here shows where we are today in terms of omnibus state privacy laws. We have about 21, depending on how you count. We are counting, including both Nevada and Florida, which have slightly more limited regimes. Florida in its applicability to larger entities with over $1 billion in revenue as controllers. And Nevada with a slightly more limited focus on sales and opt-outs of sales in that law. But you can see it's a smattering across the country. We used to have a situation where it was kind of the West Coast, California, Nevada, and then the East Coast block of Virginia, Connecticut, et cetera. That's kind of gone away. We have a lot of Midwest states and Southern states now that have passed omnibus privacy legislation. And here, this slide, we thought it just would be interesting to show the effective dates and sort of how the number of states coming into effect has grown over the years. As you can see, CCPA was the first mover. Then Nevada, we had no new laws in 2022 come online. And then in 2023, we had CPRA, Virginia, Colorado, Connecticut, Utah come online. So you can see, you know, the number of states has kind of grown each year that have come into effect. Actually, today is the first day of the effect of Minnesota's omnibus privacy law. So I thought that would be interesting to note. We still have new laws coming online constantly, consistently as we go. In terms of upcoming effective dates, important ones to note are Maryland. That one will be coming online October 1st of 2025. We'll get into the nitty gritty of Maryland in this presentation. There are some unique terms there that you should all be aware of. As well as January 1st, 2026, we have 3 more coming online in Indiana, Kentucky, and Rhode Island.
And as we look at the map as it exists today, you know, it's still a rights-based regime in the United States. legislation under consideration will continue to include the key privacy rights that we saw originally passed with the CCPA around access and deletion. Many are including correction portability. The scope of those may vary from state to state as to what data is included, what the lookbacks may be, but they still maintain that that approach as well as providing opt-out rights with respect to the sale, sharing, and targeted advertising. We have not moved into an opt-in regime despite many of the calls and claims otherwise. Marketing and advertising is still very much permitted in the United States on an opt-out basis, but we are seeing changes around what's subject to an opt-in under the idea of what is sensitive data. And to date, we're still looking mainly at a enforcement approach where the attorney generals are authorized to bring enforcement actions, though we are seeing some changes in those, particularly like in Washington around health data, allowing for actual damages for plaintiffs. But we are seeing now new changes, substantive material changes from state to state. And while there is a break in certain areas like universal opt-out mechanisms or GPCs, still the opt-out approach has been carrying on. But we are seeing things like in Minnesota, Connecticut, Oregon, and Rhode Island that are allowing individuals to have access to specific lists of third parties to which controllers may disclose information. And we'll look at some of these in more in depth in the coming slides. They're not the same across the board. Certainly what's interesting is key areas like trade secret exceptions and exclusions to some of these rights. One of the ones that I think is catching the most headlines, particularly with the upcoming effective date, is the Maryland data minimization provision. We did see this get introduced in a number of states, but didn't get through. The legislature pulled back on many of these proposals. So Maryland's still the main one with this more somewhat narrow data minimization requirement. But we have seen some bans on the sale of certain sensitive information, including location data in Maryland, and then also now going to be in Oregon. And then there's always the regulatory process. California has a number of them underway. We'll take a look at those coming up shortly. But New Jersey as well has a rulemaking proceeding taking place. That due date for comments moved from next week to sometime in September. But in the interim, Colorado announced their rulemaking. So we go to the next slide. Just wanted to sort of emphasize as you're thinking about, okay, Minnesota, Indiana, Kentucky, if I'm doing X, am I okay doing that now here in those states? And while this is not a detailed compliance roadmap, it should give you a sense, though, where there's commonality between the laws that will be effective soon and many which you're probably already operationalized your program for. So all the states are rights-based. They all have opt-outs for sale, targeted advertising, profiling. And again, profiling tends to be more in that area where profiling is used in furtherance of making a legal decision or a significant decision for somebody or about somebody. Opt-ins for sensitive data processing. Note that Maryland consent isn't a recognized means for processing sensitive information. It must be strictly necessary in maintaining and providing a requested product or service, and there's a ban on the sale of that information. We were split here on global privacy controls, 2 to 3, no private right of actions, and no regulatory rulemaking. Next slide. So as we look to Minnesota, just some things to highlight here. This is one of those states that adopted the right to obtain a list of specific third parties to which a controller has disclosed the consumer's personal information. I think importantly to note here, though, that there is a trade secret exclusion to this right, and it may be helpful as you're thinking about how to operationalize these requirements and providing these lists. And the exclusion, the elements of what is a trade secret are, pretty standard. There's 3 elements. You may want to look into that, but generally, is it a list? Does it have an economic value? Have you taken steps and efforts to maintain its secrecy and confidentiality? And it may help you operationalize and how you provide that list and what's included in that list. Another area, there are some differences in Minnesota. It's around the definition of the term specific geolocation. Most states have focused around a specific radius, whether it's 1,750 feet or 1,850 feet. This does not include that radius concept. It's more prescriptive in the sense that anything that directly identifies the geographic coordinates of a consumer or device linked to a consumer with an accuracy more than 3 decimal degrees of latitude and longitude. So we're seeing some changing in the way that legislatures are thinking about it and how do they define this terminology. One of particular interest for our group that we're helping a lot of clients think through is Rhode Island, and this requirement around providing notice by any commercial website or internet service provider. First, a commercial website must designate a controller, and then that controller, if it collects, stores, sells customers' personally identifiable information through said commercial website, arguably, they must provide in a conspicuous location on this website or somewhere on the platform a notice that identifies all third parties to whom the controller has sold or may sell customers' personally identifiable information. That could be read as being a list unique to the individual requester. It also is limited to personally identifiable information, a term which is not defined in the statute. Personal information is, so this could be a subset of that data, and maybe it's being limited to really the operator of a commercial website. Of interest is that there is an entirely different section broadly defining consumer rights around access for all controllers, which is different and separate apart from this as it applies to commercial websites. Slide. Marilyn, we noted the data minimization term here, and this is a limit on the collection, not all processing, but the collection of data must be limited to what is reasonably and necessary and proportionate to provide and maintain a specific product or service requested by the consumer. Targeted advertising is covered and governed entirely differently part of the regulation, subjecting it to an opt-out. So it raises question about how these two different provisions work together, about a limit on the use of data collected in the provisioning of a product and service, and then general uses of data. Is it limited to when you're providing a product or service? Does it provide more broadly? These are things that I think many companies are going to need to work through over the next couple of months as the effective date is coming rather soon. And then also for sensitive data, the collection here and processing and sharing, so different than just collection as in the prior term that we were talking about, must be strictly necessary to provide or maintain a specific product or service requested by the consumer. So it does not recognize consent as a means to collect the information. It's cabined to this strictly necessary. And then putting a restriction, a ban on the sale of information. And here you see the list of what is considered sensitive personal information under Maryland. I'll note here, in contrast to Minnesota, it does have the feet restriction or feet radius versus the decimal point version. Allie?
Okay, so now we'll turn to what's new in 2025. As Mike said, although we haven't had an omnibus privacy law passed this year, we've had a number of states look at their laws, re-examine their laws, and pass amendments to their laws. We've also had new laws, issue-specific laws, I like to call them, because they regulate specific issues, specific types of data, specific entities, and as well as we'll take a look at new regulations that are either pending or will become effective very soon. So this map kind of shows the landscape of what we've been really tracking this year. We're on this day-to-day in and out, seeing exactly where bills are going and how they're progressing. As you can see, the states that have considered privacy-related legislation, it almost covers the entire map, including states like California, Virginia, et cetera, that already have privacy laws on the books. So this just goes to show that without that preemptive federal standard, we're going to continue to have changes and tweaks. And a lot of times the states will see, another state pass something and then want to update their law to conform to that new state requirement. We have seen a lot of bills this year pending that would have potentially added the Maryland data minimization requirement to the state's regime. Fortunately, none of those did pass, but they were considered in a number of states. So that's just an example of what we tend to see when one state does something new, the others then might reopen considerations on their state law.
One thing to add here before we move forward is that while we've closed sessions in the vast majority of the states. There are still a number of states that'll be in session till the end of the year, particularly some of the more busy states like California, but Massachusetts, Wisconsin. In fact, this week, Representative Zimmerman in Wisconsin gave an interview stating he's quite confident and optimistic that they'll still be able to get something done this year when they return from summer recess, and said that this is not their first try. They've already attempted to pass omnibus legislation, and so he hopes that that means that they'll move quite quickly before the end of the year. So while we haven't seen omnibus legislation pass through, there are a number of states in session that don't have comprehensive privacy bills that will work to pass something this year, in addition to, as Ali had pointed out, the number of amendments that we're seeing.
Thanks, Mike. And so we're just going to take you through some of the more notable amendments that have come through this year, starting with Montana under SB 297. This amendment is effective in October of this year, same time Maryland comes online. A couple of notable changes. The amendment would change the law's applicability thresholds. So now the law will apply to persons who produce products or services targeted to residents and control or process personal data of not less than 25,000 consumers or 15,000 consumers and derive more than 25% of gross revenue from the sale of personal data. So kind of lowering the number of consumers for which data has to be processed to have the law become applicable to the company. In addition, there were changes here to narrow the law's nonprofit exemption. This is one piece of the state laws where there's not a lot of consistency. In some states, nonprofits are exempt. In some states, they are not. In other states, only certain kinds of nonprofits are exempt. So this change will alter the Montana law. So only those nonprofits established to detect and prevent fraudulent acts in connection with insurance are exempt from the law. In addition, another change that we've been seeing pop up a lot are alterations to the GLBA related exemptions in these state laws. This Montana bill will remove the GLBA entity exemption and replace it with a GLBA data exemption. And then finally, I think one of the most notable changes that this amendment brings is that it actually cuts the cure period short for the Montana law. Previously, as the Montana law was originally passed, there would have been a cure period that would have lasted through April 1st, 2026. Now that cure period will be removed from the law with the effective date of this amendment. So the cure period is only available in Montana now through October 1st of 2025, removing about 6 months through which companies would have previously been able to seek a cure. Also in Kentucky, just wanted to briefly raise that the HB 473 amended certain health information exemptions in the Kentucky Privacy Act. So if you're relying on some of those health-related exemptions, those will be changing come January 1st, 2026. Additionally, Connecticut. This was a bill, Connecticut SB 1295. There were a lot of changes and back and forth in this bill. And this was one state that actually did consider adopting Maryland's data minimization standard, but declined to do so. However, they did make other changes to their law that will become effective about a year from now, July 1st, 2026. Also changing applicability thresholds, in particular, now making the law applicable to any entity that controls or processes sensitive data, as well as any entity that offers personal data for sale in trade or commerce. So kind of removing the need to process data of a certain number of consumers or residents in the state, and applying a more broad applicability threshold to just, do you process this type of data at all? Similarly to Montana, we see a change with the GLBA entity exemption to a GLBA data exemption. In addition, we see new privacy notice requirements, including requirements to disclose whether the controller collects, uses, or sells personal data for the purpose of training large language models. This is kind of getting into disclosures related to use of data to train models, and internally for AI and other purposes, there will be a required disclosure now in Connecticut on this piece. In addition, as Mike mentioned earlier, Connecticut now joins that minority of states that require controllers to disclose a list of third parties to which they sell personal data. And finally, Connecticut added some new impact assessments and other related requirements for entities that engage in profiling and furtherance of decisions that produce legal or similarly significant effects. So now there will be more prescriptive requirements for what types of content goes into these assessments, including, for example, the assessments must include an overview of the main categories of personal data the controller uses to customize any such profiling, any metrics used to evaluate the performance and known limitations of that profiling, and a description of any post-deployment monitoring and user safeguards provided concerning such profiling, including the oversight and learning processes established by the controller to address issues arising from the profiling. So requiring a lot more diligence on profiling and furtherance of decisions that produce legal or similarly significant effects. Next, we'll talk about amendments to other laws, other legal regimes that we have in the states. Texas has amended its data broker registration law under SB 2121 and SB 1343 that will take effect in September of this year and become, relevant for the next year of registration for companies to consider. The changes are, not, I would say, substantial, but they do kind of alter the text here. So we encourage you to take a look and see if this changes anything for you in your considerations of if you are a data broker in the state. Data broker will now mean any business that collects, processes, or transfers personal data that the business entity did not collect directly from the individual who is a Texas resident. Previously, it would have been any entity whose principal source of revenue is derived from that collection. So potentially, broadening that definition slightly. Next is Colorado, SB 25-276. This was a change to add a definition of precise geolocation data to the Colorado Privacy Act. Previously, it was one of the only, if not the only state that did not include this data type explicitly and define it. And this amendment would define it and then also make it a category of sensitive data. We have the definition here. It's similar to what Mike had mentioned. Most of the other states' approaches of defining it in terms of a radius, a geographic radius of 1,850 feet. And I just note here below, previously, the real discussion around precise geolocation information in Colorado was in the regulations, the Colorado Privacy Act regulations related to what it means to reveal a sensitive data inference, suggesting that precise geolocation information at a high level might not be sensitive data. Precise geolocation data, which is used to infer that an individual visited certain sensitive locations, like a religious location or a reproductive health clinic, could be determined to be sensitive, but not all precise geolocation data was necessarily sensitive under the rules. Now with this change, we see that precise geolocation data is sensitive, seemingly potentially regardless of where it's indicating that you are. And we note that this provision on revealing is potentially going to be struck, given that the Colorado Privacy Act, there are new regulations pending in Colorado to update the proposed regulations, or the regulations in Colorado, which we'll get to later in the presentation. But to kind of, I think, align with this new amendment, this revealing term is likely to be struck from the proposed rules. And then the last bullet here is a larger impact, I would say, in Oregon. Oregon HB 2008, effective in January. This would ban sales of precise geolocation data, and as well as sales of personal data associated with U16. So Oregon now will join Maryland as the second state to ban sales of precise geolocation data. Maryland's restriction is slightly broader, all sensitive data, but Oregon now has passed a bill that will restrict sales of precise geolocation data. Next, this is an issue-specific law regulating a certain type of data, notably or personally identifiable reproductive or sexual health information in Virginia. This bill passed earlier this year and is currently effective. It took effect in July. It's SB 754. This bill, I think most important to note, actually does not amend the Virginia Consumer Data Protection Act. It amends the Virginia Consumer Protection Act, and those are different legal regimes. The privacy law in Virginia does not permit a private right of action. However, the Virginia Consumer Protection Act, which is broader, does allow for a PRA in certain instances. So this new term in Virginia could have the potential of private litigation. Essentially, it will make obtaining, disclosing, selling, or disseminating any personally identifiable reproductive or sexual health information without consumer consent a violation of the Virginia Consumer Protection Act. And the definition of reproductive or sexual health information here has some nuance that we've been thinking through with a number of clients regarding how this might impact advertising to new parents or couples with children in the home, because the definition includes, for example, reproductive or sexual health conditions, including pregnancy or the ability to conceive a pregnancy. Does the existence of a child in your home suggest that you had or have the ability to conceive a pregnancy, as well as efforts to obtain reproductive or sexual health information, including location information that may indicate an attempt to require services or supplies, etc. So the breadth of this definition and the PRA, I think, attached to it is creating some concern about how segments or different types of advertising can be done to new parents. So we've been looking at that as well. Okay. And then other issue-specific laws, kids and minors privacy remains a topic of consideration across the states. Just wanted to briefly note that Arkansas has passed a COPPA 2.0 analog to provide protections for a category of teens, defined to include individuals aged 13 to 16. And Nebraska has moved forward with in a different form, I would say, of an age-appropriate design code bill under LB 504. There still remain a number of the design elements of the traditional AADC laws and the requirements to provide minors with tools to limit interactions with others and things. But they did pull out the DPIA requirements, which had previously been struck down as unconstitutional in California. The Ninth Circuit did consider that and found the DPIA requirements in California's original AADC law to be unconstitutional. So it seems that the states are still looking at this AADC legislation, but might be taking some cues from the courts as to what has been determined to be unconstitutional. They're still moving forward with these bills, but they are adjusting their approaches slightly to try to take account for these changes. And then finally, just kind of wanted to end with an areas of focus slide to show you what we've been seeing the most of this year. As we've discussed, a lot of amendments to existing privacy laws, and as we mentioned, kind of to update their laws or change their laws in a lot of ways to mirror the approaches of other states that are coming online, or to take, make even more restrictions, I would say, to kind of set their state apart. We're also seeing a focus on location data. We mentioned, Maryland, there's a restriction on sales. Now, Oregon, there's a restriction on sales. And California is also considering a restriction on collection or use of precise geolocation information as well. I believe that bill number is AB 322 in California. Kind of a different standard here, not a blanket restriction on like sales, but tying it to more of a data minimization standard. So limiting collection and use of that data unless it is necessary to provide goods or services requested by an individual. Also, as we mentioned, reproductive and sexual health data, we've seen a number of bills on this data type, limiting use of this data type in the wake of the Dobbs decision. And as I just mentioned, some of these bills may have implications for companies aiming to target advertising to new parents, as well as companies that collect or process location data. In addition, we've seen a number of bills related to surveillance pricing this year in states like California. There's one still currently pending, Colorado, Georgia, and Illinois. These bills would prohibit setting a price offered to a consumer based in whole or in part on personal information gathered through an electronic surveillance technology. Defined very broadly, these bills bring up questions as to, are we able to continue to offer discounts to consumers based on information about them, discounts to senior citizen discounts for movie tickets or things like that. So how much information can be used to set a price or a discount. Finally, and which will be a bit of a focus of the latter half of our presentation, data broker bills. We've seen a lot of these bubble up in the states this year. Proposals in Washington and Maryland actually would have created new data broker registries in those states, as well as subjected data brokers to new taxes. So taxing data brokers kind of directly correlated to the amount of data that they process in their capacity as a data broker. Also just want to raise that obviously the 4 states, so I'll just recap, that do currently have data broker registration laws are California, Oregon, Vermont, and Texas. California's is by far, I would say, the most kind of robust, because California does include the Delete Act in their data broker registration scheme, where all data brokers have to observe a centralized deletion mechanism. The delete request and opt-out platform that is going to be stood up by this California Privacy Protection Agency. We are actually seeing states such as Massachusetts either propose bills that would leverage the CPPA's delete mechanism or require the state itself to set up its own mechanism similar to the CPPA's drop mechanism. You can see here in Massachusetts, there's a pending broad privacy bill, and one of the terms would require one of their agencies to partner with the CPPA to make available their own, that's the California accessible deletion mechanism, to Massachusetts consumers, or to establish their own deletion mechanism. So states are taking cues from California on this deletion mechanism piece. And with that, I'll turn it over to Mike to discuss more considerations related to data brokers.
Questions are starting to come in. We're working through those and try to respond as we can. One, there was a question, the individual works for an organization that operates nationally and is asking how they go about adopting or aligning their program to comply with all state privacy laws. And that probably in and of itself could be an entire webinar. But I can say what we are seeing, the approaches that different companies are taking. Some are doing it on a state-by-state basis. Certainly scoping rights to specific requirements in states is one way to go about it. That is rather complex in some cases. We are seeing other companies taking a national approach or a regional approach. So, based on the 20 states, they'll provide a program and rights specific there, not other states. But those that are doing a national approach start with a baseline. Could be California, it could be Connecticut, and then identifying the differences. So up or below regulatory perspective wise as to, we'll honor GPCs here, but not there. Or we also have to provide the right of access to lists and sort of change their program based on those requirements in those states. So there's a little bit of a tailored approach based on the requirements in the state, but starting from a baseline foundation, and that's something we've seen companies successfully implement for addressing these requirements under the various state laws. We're also at the midway point, so I just want to share the CLE code. It's State 2025, all one word. And so we'll again share that later on during the presentation. We're now going to take a look at data brokers. While this may appear, or you may think that this is something limited to a narrower set of actors in the marketplace, what we're seeing though is that this has impacts for the broader business community, not just by restricting access to information and services provided by third parties, but also that some of these proposed regulations would directly regulate first parties, brands, in ways that would not thought of happening. Because as we go back to where this started, we go to Vermont, and Vermont had defined data broker, and I think in a way that many of us in the industry understand to be data collected by an entity that does not have a direct relationship with the consumer. And then they broker that information. They'll sell that to third parties. And we see here Vermont's definition, the bolded red language, just a key on it. So you collect and sell consumer data with whom the business does not have a direct relationship. And they give examples of what a direct relationship means in this context. It's your customer, your client, your subscriber, user, so forth. And then when we go to Oregon, which was another one of the four. On the next slide, still the same concept of a direct relationship, but not using the terminology. They use it as an exclusion. So an entity that collects and sells licensed, or collected broker data, and carves out from data broker those entities that have a subscriber customer relationship, registered users. So still this concept of having a touch point with the individual. And then we go to California, and this is probably the most acute example of the change over time. And in 2019, when California passed its data broker registration, it defined data broker to be a business that knowingly collects and sells to third parties the personal information of a consumer with whom the business does not have a direct relationship. Then there was, in the legislative intent section, as you can see here, 2 paragraphs talking about the difference between a data broker and a first party and the types of relationships, and consumers having knowledge that they're interacting with a particular company and then can go learn about those practices and exercise their rights. But then as we move to the regulatory process, some 5-6 years later, the agency, following the Delete Act, promulgated a regulation that went in effect in 2024. You can see here in the bold language in red where they've defined direct relationship. Say a business is still a data broker if it has a direct relationship. So there is some intentional interaction between a consumer and the business, but also sells personal information about a consumer that the business did not collect directly from the consumer. So a brand that is doing prospecting and acquiring information from a third-party source and then activating that information on a platform, that could constitute a sale or a share requiring registration. And we have already seen this year first parties and brands starting to register in California as data brokers for that exact example, acquiring information from a source other than the consumer for prospecting, marketing, and advertising. And then through the regulatory process at the agency through 2025, there's proposed regulations under the drop proposed regulations for implementing the Delete Act, where they would again revise this definition one more time to new information about how a business is still a data broker, but it's focusing on the nature of the interaction, whether the consumer intended. They must intend to interact with the business, and could still be a data broker and does not have a direct relationship with the consumer as to the personal information it sells about the consumer that it collected outside of a first-party interaction with the consumer. And the first-party interaction means a consumer-facing business with the consumer intends to and expects to interact. So raising questions about what is the interaction and what is the scope of the Deletion Act as it applies to these arrangements. And as Ali had pointed out, we've now seen it go from a registration requirement and talking about the interactions, the nature of those interactions between businesses and consumers, to Maryland, which would had implemented or enacted a registry, which likely would have been a business registry, not a data broker registry, because of the way that they define data broker in Maryland. You can see on the next slide as it advances that a data broker is an entity that engages data brokering. And data brokering means any act of collecting, aggregated, analyzing, buying, selling, or sharing brokered personal information. So anyone that is receiving information through collection could be a data broker. In this case, there was going to be a registration requirement, and it was being leveraged for a tax, statewide tax on businesses. This bill did not eventually move through an action. There is a possibility that it could come back through some sort of budget resolution this year or next year for consideration. But this model and what we've seen once proposed one place is being considered in many other places. We saw that with the APRA from Congress being introduced in a number of states this year. So despite the APRA never being brought up for consideration in the House Energy and Commerce Committee last year for a markup, it is being held out as a approach to consumer privacy being copied from state to state. And this approach in Maryland was also then copied in Washington this year. Again, didn't get through, but you could see data brokerage means the collection, buying, selling, and sharing of brokered information. So removing this concept of a relationship, the exclusions about working with your customer, having those come out from the requirements and the scope. So here, I think this is a cautionary note. Think about how these regulations as they evolve can apply it more broadly, but also look at your current practices, particularly in California, and consider whether your activities would trigger registration requirements in California, as well as then integrating into the drop mechanism, which then will be up and running, proposed wise January of next year for consumers to start registering their deletion requests, as well as then having those requirements be required starting in July of next year. So Allie, why don't you take the next part? And I think you have an answer to one of the questions that came in, if you could lead off with that.
Yeah, I think one of the questions was on Maryland and the enforcement date for the law. And yes, the law is effective October 1st of this year, but it applies prospectively and only to doesn't have application on any personal data processing activities before April 1st of 2026. So we're looking at that as the enforcement date, April 1st of 2026. There was also an acknowledgement that the Maryland law does change data minimization rules and rules regarding sharing or selling of data aside from targeted advertising, and whether there are any exceptions to this requirement. Most of the exceptions in the Maryland law are similar to what we see across other states. There, are some more specific elements of the law which we've gone over here, but the exceptions are mostly in line with the other state laws. So there might not be as much relief there for some of these things. But the enforcement date, just to clarify, is April 1st of 2026. So next, we're just going to talk about the state regulatory processes that are ongoing in various stages, starting with California. We have mentioned their effort to implement rules regarding the delete, request, and opt-out platform for data brokers. We mentioned that, they're changing the definition of direct relationship, which is impacting the state's data broker definition and broadening the actual application of that term and who is a data broker in California. They're also promulgating regulations to stand up the delete mechanism itself and to put some rules around, how the delete mechanism will function, and data brokers, what they'll need to do. They'll essentially need to download certain deletion lists from the agency and compare them to their own databases. There are some proposed rules regarding standardizing database structure and how data is maintained to be able to match to these deletion lists, as well as some rules around how the hashing algorithms need to be completed in terms of cross-referencing this data and executing the deletion, as well as rules around reporting the status of the deletion requests. Deletion request honored, deletion request not honored, deletion request couldn't be verified, so it was converted to an opt-out request. So there are a number of kind of more specific requirements that are coming through in those proposed regulations. Most recently, the California Privacy Protection Agency held a board meeting on July 24th, just last week, and have indicated that they're going to advance an updated version of their proposed drop regulations for comment. We're anticipating it's going to be a shorter comment period, a 15-day comment period, because as Mike mentioned, they're under a bit of a timeline statutorily to finish these rules. So those will be out for comment one more time, and then they will likely advance towards finalization. Additionally, wanted to highlight that California had a separate regulatory process ongoing related to a number of topics, including automated decision-making technology, risk assessments for certain processing activities, cybersecurity audits, insurance companies, as well as amendments to existing CCPA regulations. During that board meeting last week, the board voted to advance their package of rules to the California OAL for consideration, so signaling this is one of the last stages in that package's development. California OAL will have 30 days to review the rules and approve them. Specifically, these regulations have changed quite a bit from when they were first introduced. If you recall, when they first were introduced, there was a proposed term behavioral advertising, which would have applied to first-party advertising activities. whereas the CCPA itself regulates cross-context behavioral advertising, so the use of data across sites, distinctly branded websites, et cetera, to target advertising. Previously, the California proposal would have included an opt-out for first-party advertising. That has fortunately come out of the rules. It no longer remains in the package that has been advanced to OAL. To highlight that. Next, just to note, Colorado just put out a request for comment related to data associated with minors. They're going to update their regulations on this piece. Comments in response to that proposal are due September 10th, 2025. And then finally, New Jersey. New Jersey has published proposed regulations to implement the New Jersey Privacy Act. There are a number of unique provisions in that proposal, including notice at collection requirements, which you might recall from previous proposed regulations in California, which those issues got worked out through the regulatory process, as well as consent required for the use of personal data in artificial intelligence with no definition of artificial intelligence, as well as an immediate deletion button option. These are just a few of the proposals that are pending in New Jersey. As Mike mentioned, comments were due this week. They've now been extended to September 2nd, so there's a little bit more time to get in your thoughts there. Finally, we're going to turn to lessons from enforcement and counseling.
Yeah, we had a question about a bill in California. I think it's AB 322. It's the geolocation bill and the restrictions there. It would amend the CCPA, and so all the definitions there would carry over to this proposed bill, including consumer, which is defined broadly to include employees. There's not an explicit exclusion for employers in the bill. There is an exception for security purposes, but it's responding to security instances rather than just broadly. The question was about whether or not there's an exception for employers around building security, cybersecurity purposes. So you'd have to look through the amendment and integrate it into the CCPA to look at the broader set of exceptions there. On enforcement asks and actions, we've seen an uptick this year in the number of actions brought in California. We will cover some other states, but there's been an obvious and quite public collaboration happening through the states. This year there was an announcement of 7 states working together for information sharing around enforcement, and there's been several public comments made by enforcers about identifying the more stringent laws for enforcement, helping find amendments to bring other states up, or which states should take the lead in investigations. We're going to highlight a few here in California, Connecticut, and talk through what we think some of the key takeaways are from the cases. And I think many are probably familiar with these cases, Honda, Todd Snyder, and Healthline. These are all happening now in the last 3-4 months from both the agency and the Attorney General, with fines now reaching over $1.5 million in the most recent case in Healthline brought by the California Attorney General. We go to the next slide. We have here a list of some things that we've been focusing on that we know that companies are thinking through and identifying what some of the key takeaways are. And one is this concept that we've seen in a number of cases, consumer verification. And in California, in these enforcement actions, it was a restatement of the regulations that verification is permitted for all rights except the right to opt out. And there was allegedly some companies were still verifying opt outs. And then the nature of the information requested to perform verification, some cases, the Attorney General agency took issue with that. In fact, one company was allegedly requesting government ID for verification purposes, and the settlement noted that there was other data available to this business in its databases, which would allow for verification that a government ID was unnecessary. So looking at the data types, the nature of it, the number of data points being requested, and looking at what the regulations provide for verification, and depending on the type of right at play. Consistently, we're seeing themes around contracting and vendor oversight. Many cases are pointing out that the agreements between a business and third parties or with their service providers do not include all of the required contractual language. But recently, we were also seeing things around the lines of industry compliance programs and the need to have oversight to other signatories there and doing diligence around whether or not opt-out signals are being passed and being honored, and having some level of visibility and even control in that process. So something else to think through is knowing your partners better than just having contracts in place, and particularly your vendors that are helping with compliance. There's been a lot of focus on CMPs and cookie banners and how those are being presented. And Ali will talk a little bit more about the presentation of those choices and whether or not they're opt-outs under law. We had the agency that was saying a cookie banner could be seen as a way of providing an opt-out for sales and cross-contextual behavioral advertising. And the Attorney General, shortly thereafter, in its own enforcement action, said that a cookie banner isn't strictly an opt-out under the CCPA, but raised concerns around deception because the company allegedly wasn't honoring opt-outs as promised through the banner. Checking the functionality of the opt-out mechanism is also important. Many companies may be disclosing that they're honoring GPCs, but ensuring that that the back-end operations are actually seeing signals and operationalizing them. Another one is observing purpose limitations. This was something that came up in the Healthline case, where the AG was saying that individuals, or alleging individuals that are reading diagnosis articles may not be aware that the titles were being shared for advertising purpose. That might be on the expectations of a consumer, and thinking moving that more, what appears from the settlement, to a sensitive category rather than general personal information. And then finally, updating privacy policies with the necessary specificity. This again is disclosing this use so it fits within the data purpose, data minimization terms. We're also seeing a focus on the wording in privacy policies and making sure using language consistent with the statute, and a lot of attention on notice at collection and how that's being presented. Here, you'll see this when we send this around. It's just a chart showing all of the enforcement actions in California, the fine, and whether it's related to the violation of the data broker registration requirements versus the CCPA. You can see anywhere from the tens of thousands up to 1.5 million. Ali?
Yes, and also, California has definitely been, I think, the main driver of enforcement thus far, but we have seen other states step in, most notably Connecticut very recently on July 8th announced a settlement with a company ticket network related to the company's privacy notice being unreadable, missing key data rights, and having rights mechanisms that were misconfigured or inoperable. So I think that's something in particular we see now across the states. You can't just offer the right, you have to make sure that it actually works and functions. So Ticket Network agreed to comply with the law, maintain metrics for consumer rights requests received under the law, and provide a report of those metrics to the Attorney General and pay an $85,000 fine. Also, the Connecticut Attorney General's office produced an updated enforcement report earlier this year and highlighted a few points for consideration. On privacy notices specifically, the report suggested incorporation of the Connecticut law and specific reference to the law's consumer data rights by name. This brings up the question of, do I have to disclose every single state for which I'm honoring rights in my privacy policy? It seems that Connecticut is looking for a disclosure potentially of their state in privacy notices. Also focused on marketing and advertising, specifically discussing a cremation company sending a mailer to a Connecticut resident who had recently completed chemotherapy. They did an investigation into this and signaled a focus on data services companies and analytics firms and data brokers that provide that information to identify individuals for marketing lists. Another focus was connected vehicles. The report discusses a cure notice that the Attorney General sent to a car manufacturer, resulting in updates to the company's privacy notice to clarify what personal data was collected from consumers versus employees. And the report noted that the Connecticut AG is focusing on the connected vehicle space and has since expanded its review to include other car manufacturers. Additionally, problematic opt-out mechanisms and dark patterns. This is something we're seeing across the states in many different formats. Suggests a focus on cookie banners and symmetry of choice, having an agree or accept all cookies button to opt in versus a show purposes button, or an additional number of clicks to opt out of a particular data use or sharing. It seems that enforcers in both Connecticut and California want to see the symmetry and choice and the same kind of number of steps to take to execute an opt out versus an opt in. Additionally, we definitely want to mention the recent surge in lawsuits alleging wiretapping claims in the context of use of cookies, online tracking technologies, and session replay technology grounded in these older kind of wiretapping laws in the need for consent from two parties to a communication. So a lot of the lawsuits here are leveraging laws with two-party consent wiretapping statutes. State laws require careful construction of cookie banners and related disclosures to kind of stay out of the fray of these lawsuits. The banner should be unavoidable and it should function. We've talked about symmetry of choice and accept all buttons versus multiple steps for opting out. Avoiding dark patterns and consumer confusion, making sure that the cookies for advertising are not firing before the banner is presented to the consumer. In addition, requiring a review sort of these off-the-shelf products and vendor solutions. The things that are provided off the shelf these days require a second look. Do they need to be customized to your company to make sure that they are disclosing accurately how your back-end processes and your opt-outs work? Also just wanted to note briefly that there is pending legislation in California to kind of add a commercial business purpose exception to SEPA to kind of stem the tide of these lawsuits. It's SB 690. Most recently, the committee that was considering it suggested that they were generally in support of it, but wanted to take more time. So this has been pushed to a 2-year bill. So we might see this come through next year. The passage of this would help stem the tide of some of these lawsuits, at least alleging SEPA allegations. Finally, turn it back to Mike on data brokers.
Yeah, this is our final slide. Just a bit of a summary to think through. It might be covered earlier around data brokers. Obviously, there has been quite a few headlines around enforcements for a failure to register, and there are some compliance considerations, and I think cover those. But think through your own receipt of data, the sources of it, how you're using it. Does it create any kind of data brokerage, which would require registration in California? Through the New Jersey rulemaking, they too are proposing a broad definition of data broker, setting a foundation likely to come back in the future to add to it through registration requirements and possibly similar delete act requirements. And thinking through when you do receive these deletion requests, how do you operationalize those? They do quote unquote convert to an opt-out if you're not able to match a request. So it does have some limitations on the processing of information once these requests are received. And there's some proposals right now in California requiring or would require data brokers to provide additional information, including the identifiers that they use and provide to the agency, declarations around whether or not they sell data to foreign adversaries, picking up from some of the developments in Congress of last year through PATFA or the DOJ bulk data rule, and also a bill allowing for elected officials and judges to California to send requests for their information not to be disclosed. But what's unique in California is that it would allow the agency to make those requests on behalf of these covered persons, whether the covered person makes the request to the agency or not. It would allow the individual to opt out from the list that would be sent by the agency. So an evolving area for sure. So that concludes our presentation for today. Thank you all for joining us. We'll be back again in a few months for a recap and a forecast. But until then, your CLE code is state 2025, all one word. Again, state 2025. Thank you and hope you enjoy the rest of your summer.